This is attorney Juliana Gaita, and I'm sitting with attorney Mishael, and we're a little bit early, but we figured we would kind of hop on and give people some time to get on to the live, which is really going to start at 10 o'clock. So I guess I'll start by kind of introducing myself. As you guys know, if you've tuned in before, I am an adoption attorney in the state of Florida. I'm board certified in adoption. I handle cases when they intersect a lot of times with the dependency world, which is foster care, juvenile dependency. And a lot of my knowledge kind of comes from the fact that I've adopted children from foster care, or at least my knowledge comes from the law, but I think a lot of my insight, I would say, comes from the fact that my husband and I together have adopted 3 children from foster care. And should I let you introduce yourself, Alan? Or?
Sure. My name is Alan Mishael. I'm an attorney practicing in Florida, predominantly adoption law, in the foster care system, at the trial and appellate level, and also in administrative proceedings with the Department of Children and Families. I've been involved in a fair amount of legislative reform over the years concerning the powers of DCF and the courts respecting adoption, concerning administrative hearings for benefits, a fair amount of work in the field of adoption subsidy and enhanced adoption subsidies, and sibling placement issues. All of these are largely coming to the fore at this time in Florida history. There are some major pieces of legislation currently pending in the legislature and other administrative steps that have been taken that are going to, without a lot of fanfare, change the face of Florida law and the rights of foster parents and other caregivers in the child welfare system.
Yeah, so that's what we're going to kind of discuss today. So in my last video discussing legislative kind of actions, we were discussing, it was about, I guess, a little over a year ago, because it would have been in 2021, July of 2021, when the last session laws that they passed went into effect. So we kind of discussed what those changes were, and now these are proposed changes to that same statute, Chapter 39, and here there's also some proposed changes to Chapter 63, which is the adoption statute, but it's the part of the adoption statute that really intersects with dependency and juvenile dependency, and in the context of interventions, which we'll get into in a minute. So we kind of last time were just discussing what already went into effect, but now they're trying to change the statute.
And so what they're doing now in 2023 is building on other changes that took place, that were enacted in 21 and went into effect in 22, and that are drastic changes in Florida law, mostly for the better from the standpoint of custodians. But there are some chinks in the armor of child welfare protection of children, and we deal with those quite frequently now in working through the statutory issues that were created in 2021, particularly in areas of sibling separation and sibling placement.
Yeah, actually, so I think that's funny that you said that, though, because I think that, to me, when we're going to be talking about the bills, I think one of them is a little bit better for foster parents, and it's like, okay, great, we're moving in that direction for caregivers. Right. And then the other one rolls it way back.
Exactly.
So it's kind of, it's an interesting session, I guess.
It is.
We'll see.
Why don't you talk about the intervention bill?
You want to talk about that one first? Yeah,
because I think that's what you were alluding to.
It is definitely the most exciting of the two, I guess, from my perspective. But to start with, just to give a little bit of background, what we're talking about is House Bill 1201. There's a few bills actually out there, and we can't talk about all of them in a quick 20-minute, right, 30-minute thing. So we're going to talk about 2 of them, and then maybe we'll schedule another session to come back. But so we're going to talk about today House Bill 1201 and Senate Bill 1322. And I really want to encourage everybody to go on and read these, and they might look a little intimidating, but it's really easy. So if you're looking at it, I'm not going to be able to really show on the screen because I think it'll go backwards, but if something is underlined, it means they're adding to that's language they're adding, and if it's crossed out, that means it's language they're taking out of what is currently the law. So, so you guys should really read them. They're not hard to read. You just kind of have to know that, and we'll put a link after this to where they can pull the actual bills from.
But if you don't get the link or you don't see the link, just go to Online Sunshine on your Google search engine, 2 words, Online Sunshine. You'll have a page for the House, a page for the Senate, and click in the bill number, and it ought to pop up on your screen.
Okay. So you want to talk about the intervention statute first?
Sure.
Okay. So that is Senate Bill 1322. And that is actually trying to amend Chapter 63.082, which is the adoption statute in Florida. And so currently right now, there's a process by which parents, birth parents can make an adoption placement for their children. So I think there's been rumblings of that. People have heard the word intervention and what that means. And some of my clients, even who might be on here, have actually experienced that happening where, you know, it's been maybe years and at the last minute, the parents decide that they are going to exercise that fundamental right to make a placement decision for their children and to then choose to do a private adoption. And now we're in courts trying to figure out where, you know, what's best for this child based on the 8 factors that were currently listed in 63.082. But overall kind of speak to the best interest of the child. And then foster parents maybe, or caregivers who have cared for this child for X number of years are left kind of trying to figure out a way into the case to either, you know, possibly oppose this or to even be involved in some of that decision-making process when it comes to a transition, if it is going to happen that way.
This is a very turbulent area of law.
Yes.
There are a lot of different interest groups whose interests do not always coincide and are often in great opposition to one another.
Right.
Basically, once there's a child welfare case pending against birth parents, what is the scope of their authority to choose someone else to adopt the child and take the case out of the child welfare system instead? How long should the child be protected? For example, if the child's been in a placement for a year, 2 years, 3 years, should the parents' right be somewhat diminished, or is that irrelevant because they have a fundamental right, even though they don't have the child themselves because of the child welfare case, of choosing who should adopt the child?
Right. So it's kind of always a little bit of a balancing act. So I think originally when this statute was enacted, it was this idea of sometimes birth moms are making an adoption placement and they don't sign the paperwork in time. I'm actually doing a case like that right now where the child hasn't even been placed yet. He's still in NICU. Birth mom just wasn't ready to sign, but now she is. It was meant to be an adoption all along.
Right.
And so this is an opportunity for the private sector to kind of help out a very overwhelmed public sector where there could be some really copacetic and synergies, I guess, in making this be a private adoption. The problem becomes, I think, anyway, when you've had children that have been in care for like over a year, over 2 years with the same caregiver who wants to possibly adopt, and now we're moving to someone that the child doesn't know, or someone maybe that the court has already said couldn't be a placement, but it's a different process when the birth parents choose to make an adoption.
So here's the simple scenario. The mom tests positive for drugs when she's delivering, okay? But she's already set up a wonderful placement through an adoption agency. But when the mom tests positive, child welfare steps in, they take over the case from the private adoption agency, and they say, we're now in charge. The bill was basically intended to curtail that kind of government overreach when it wasn't necessary. But what we see now is it's being used to disrupt placements of 2, 3, 4 years duration, and there are tremendous economic disparities between the foster parents often and the adoption agency or the adoption attorney's clients, and it can be very, very unfair and detrimental to the child. And it's a very controversial area of law in Florida.
Right, and I think now, so as an adoption attorney, I think that parents have the fundamental right to make placement decisions for their children. I think where it's got to be a balancing act of what's best for the child, though, that constitutional right versus what's best for the child. Right. And what I think we have currently right now is it's not a level playing field. Whereas that's what we talk about that all the time. Like, to me, there's got to be due process and it's got to be a level playing field for everyone. That's what's fair. That's what I would support. So I think this bill
moves it
moves it in that
direction.
direction a little bit,
Yeah,
right?
yeah.
The only thing, so we're talking about it, so one of the things this changes is right now a parent whose rights have not been terminated can make an adoption placement for their child, can attempt to sign consent and make that adoption placement at any point. This bill proposes that once a termination of parental rights is filed, a petition for termination of parental rights is filed by the department, or really anybody, I guess, could be the guardian program or the attorney ad litem. But anyway, once that petition's filed, they no longer have that right. So we've kind of discussed that. I personally don't agree with that.
We don't-
Arbitrary kind of, if the parents' rights are intact, they're intact. I don't know that the filing of something changes that.
Yeah, if the department unilaterally chooses to file a TPR petition, that should not curtail the fundamental constitutional rights of the
Right,
birth parents.
right.
Okay, now if parental rights are terminated, then their whole statutory right goes away because they're no longer the parents. But up until the time the court decides their rights need to be terminated, their rights are intact and they should be allowed to do an intervention.
Yeah.
That's the one criticism I have of this bill.
That's it. That's mainly my main criticism
Yeah.
of it too. I think probably because as adoption attorneys we do recognize, and also we've talked about. I think it's a slippery slope for everybody involved, right? If the government kind of can come in and say, well, but once we've filed a petition of termination of parental rights against you, you don't have one of the rights as a parent anymore, which is to make that with that fundamental right of being able to say, you know, if you're going to place your child for adoption. I think that's a slippery slope for all parents because I think it waters down parental rights overall in general, not just people who have found themselves in
Which
hot
is
water with the department.
Which is
So,
a nice segue to the other bill.
yeah, I guess, but there's a lot to unpack on
Okay,
this
fine.
one still. So I think one of the things that it also changes that I'm not a huge fan of, I think. So right now the process is kind of, and courts have seen it differently, but the way I interpret the statute is that the process is an adoption entity gets the consent of the parents and they file a petition or a motion for intervention.
Move to intervene.
And they move to intervene with the home study and all of that good stuff. And then they go to hearing, they are allowed to intervene, or they are the statute right now is not really discretionary. It says they shall be allowed to intervene. And then you go to another hearing on the best interest. Now, I've seen courts interpret that a little bit differently, but that's kind of my interpretation of the statute. So the statute kind of changes that. The new proposed legislation changes that. It talks about they have to ask to be allowed to intervene. So I think it makes it less discretionary, or more discretionary.
There's going to
rather.
be massive case law on every sentence of this new bill if it's enacted.
And then the other part of that is it sounds like you have to go to both of those hearings at one time within 30 days. And I do think that's a little unfair for everybody, really, for the adoption entity, because they're not going to have time to do discovery and do what they need to do. And then later on, it kind of makes the caregiver a party to the action, but the caregiver is not going to have enough time to do what they need to do discovery
Or
in 30
resources.
days. Yes, I just think that's basically then becomes kind of perfunctory, where you're just going to a hearing, but nobody's going to be super prepared for it because you're not able to peek behind the curtain of what's going on in that time frame or do depositions or whatever
But
discovery.
on a broad level, though, the bill attempts to level the playing field,
Yes, I appreciate that sentiment.
which is important because right now the law is oriented toward facilitating adoptions with very few constraints, okay? And often based on economic inequality in terms of advocacy.
Yeah.
Often the department will see this as an opportunity for the child to wind up with a great family no matter what, as opposed to all the other cases the department has. So they may be more focused on other cases than these, where they feel things are more under control no matter what the outcome is. Okay?
So we got one of the questions. So the proposed changes would go into effect July, right? I think
Should say
July.
at the end,
Yeah,
goes into effect.
let's see. I think if that's at the end of the bill, July 1st, 2023, is if this were to pass, that's when it would go into effect. So one of the things that it does in the intervention statute is it changes the 8 factors. I think it's down to 7. It eliminates the one. Basically, if a parent's rights had been, if a TPR had been filed, based on certain criteria, I think it's like pretty much egregious or like sexual in nature, then the court could take that into account when determining, I guess, if the parents really have the right to make a placement decision because they've done something so egregious. But it kind of takes that out because it's saying once a TPR is filed, parents can't do this anyway. So it removed that criteria. And then one of the main things that it does is it talks about the caregivers, if they've had the child for a certain amount of time, being 9 months, which mirrors the language that we saw in 39.522, which was what I discussed in the last video, the legislative change that went into effect in July 2021. So it talks about that caregiver can now become a party to the case. And so without having to figure out a creative way to become a party to the case, or if you weren't already a party to the case by virtue of having filed your own termination of parental rights petition, you get party status. It does that weird thing again, which 39.522 does, where it says your party status ends the second the judge enters an order, which means I guess you have no right to appeal, which I think is
they did that in the 2021 legislation. I think,
but nobody's challenged that yet.
There may be constitutional issues as to the legislature's ability to eliminate the right to appeal.
Yeah, I think that's probably unconstitutional, but nobody's challenged it yet, so we don't know. But they kind of mirror, mimic that language. But that's the main thing that it does that I do think is kind of a step in the right direction, and it kind of levels the playing field for foster parents to be able to say, okay, they've elected to choose private adoption, but we've had this child, and the court gets to hear all the evidence and determine really what is the best interest of the child and weighing those factors. Not comparing the homes still, because we have that case law that says you can't really compare the two homes, but just overall, holistically, maybe looking at this child and some of that substantial and competent evidence. I think they talk about that. So really experts need to be involved.
In other words, there's some adjustments to this bill that ought to be made, but on balance, it's a very good bill.
I think so. And then the other main thing that's added in here is kind of this the adoption entity has to talk about the fees that they're getting in order to do the adoption.
There's an awareness in this bill of the economic inequality between the people who have the children, typically foster parents or relative custodians, and the people who are in a position to hire adoption agencies to seek to have the child placed with the adoption agency's clients.
Right. So it says in section, I don't know, but it's number 2, the fee and compensation structure of the adoption entity creates an undue financial incentive for the parent to consent or for the adoption entity to intervene. So it kind of talks about you have to be more transparent with that to the court, I think is what it's offering, right?
The legislature, this bill at least, is reflecting an awareness of the economic inequality and that this should have an undue role in the decision of who adopts a child.
Right. All right, so that's that bill. So, I think that one has some positive effects for foster parents.
Now what do we turn to?
But now we have one. If I had to choose, I would rather that not get passed than have this one not get passed. If I could just, I wish, best of both worlds. I would love for 1322 to get passed and then this one to kind of get flushed that we're going to talk to, which it did last time. So this is an attempt to do something they already tried to do.
Okay.
Right?
So in 2004, the legislature, as well as the Florida Supreme Court, held, respectively, that DCF does not have control over who gets to adopt children out of the child welfare system. And both the legislature and the Supreme Court held in separate actions that the court has the right to waive DCF adoptive consent when the court determines, based on admissible evidence, that it was unreasonably withheld. Since then, there has been great gnashing of teeth within the government against that bill, and that culminated last year in a bill to essentially eviscerate it, to wipe it out through imposing so many new conditions on getting yourself in front of a judge. Let me give you an example. Right now under the law, if you believe DCF has chosen the wrong person to adopt, and they should have chosen you to adopt, okay, you have a right to file a verified petition for adoption, and you get your day in court. Okay, now you have to have a favorable adoption home study to do that, okay? Even if you're a grandparent, you need that. As long as you can staple that to the petition, You get your day in court like any other citizen. What the department and DCF have teamed up to do last year and this year is to try and make that so difficult that you never even get the chance economically and through all the hoops that are being presented to file that adoption petition. And what's important is they're trying to impose these hoops before you even get access to the record in the case, to the facts of the case. Essentially, you're going to be much more in the dark when they're imposing these hurdles than when you file your lawsuit and then you get access to civil discovery before your case is tried.
Right. So last time when they tried to do this, we kind of set up like a grassroots effort, and we were explaining to foster parents why this, like at first blush, it kind of seems like, okay, well, when you file those 120 petitions and you have litigation ensuing over children, it does seem like it keeps children from achieving that permanency. And that's kind of how they're packaging this proposed legislation, is like, we want to help children achieve permanency, which of course we do. The statute provides they're supposed to get permanency within a year. We all know in practice that very rarely happens.
And why doesn't it happen?
Well, it doesn't happen because the parents are entitled to due process.
Right.
So, and so it has to play out, because we're talking about removing a fundamental right of parents, and that has to play out, and it has to be done a certain way. It's important to all of us that it's done a certain way. Not, I mean, obviously to the children, obviously the foster parents, but we don't want government coming in and taking people's parental rights away without due process, right? We think we can all agree on that.
Because there's a stopwatch.
We can all agree on that. So, so it has to play out. So I kind of think that's a similar concept here. Like, why are we now taking away due process from foster parents or caregivers or whoever believes they were not chosen properly to adopt the child? We're kind of taking away a little bit of that due process, because what we're saying now is that you have to file a motion with the court to even be allowed to file your adoption petition. So you have to file a motion with the court, and you have to ask the court if you could please file a lawsuit, essentially, which is like, I can't think of anywhere else in the law where
I imagine you were run over by a driver and you had to get his permission to sue him.
I don't know, it's that extreme, but it's kind of close. So that's kind of the first step. And then the standard of review is discretion, is abuse of discretion. So it basically kind of means, is there any way that, like, no one on earth could have come to the conclusion that they came to? And so that's a really high standard to me, where right now the standard is, has the department unreasonably withheld their consent for the adoption?
What we're looking for is any empirical evidence of the department that there's a widespread problem of delay. Okay? In all cases in the child welfare system, there are going to be certain cases that take longer than others. Okay? And there are ways to curtail that, and there are alternatives to what the department is proposing that we have articulated. But the department has chosen not to do it. The Guardian program has not chosen to do it. They want to eliminate the right to challenge their decision who should get adoptive consent. And on top of that, they want to squeeze the applicant into a abuse or discretion standard rather than a reasonable basis standard. And we think this is very bad legislation, and it should not be. It's seeking to undo legislation that was passed by a nearly unanimous Republican House and Senate in 2004 and became law under a Republican governor.
Right. And that was actually, you were one of the people that helped to write that law back then, right? So, and Nan Rich was the
one of the sponsors.
One of the sponsors of the bill. So that was passed under Jeb Bush. So that, you know, it's funny that we're like kind of, we're still with a Republican majority, but that we're moving in this direction opposite of that seems kind of odd to me. But in any event, I do think the other part of this is that you basically, right now, you would be able to file that petition for adoption. And you can then conduct discovery just like any litigant can.
What does that mean, discovery?
Well, like you could take depositions, you can ask, you can kind of peek behind the curtain in the decision-making process of why they chose that other family versus you, or why they're choosing to move the child. And right now, currently, too, they can't just move the child just because they chose somebody else necessarily. But under this statute, you have to go to court within 30 days, essentially, ask the judge if you're allowed to file a lawsuit. If the judge says no, they can move that child, basically. And that's that. And I mean, it's literally that's that. There's nothing else you can do. I mean, I guess you could still go through your administrative process, but I liken the administrative process to banging your head against the wall because, I mean, there's a place for it, but you're asking the department to determine that the department did something wrong. So like that's not really ever going to happen. The administrative process is not where you necessarily win cases, here and there, but usually that's done in conjunction with getting this in front of the actual judge so the judge can see the whole picture. And that's what I was talking about, leveling that playing field. Just let the judge see everything. Don't hide the ball.
You see, what they're trying to do is you can't challenge DCF anymore in who they choose, and DCF is going to have essentially veto power through a narrow standard of review in whatever happens in court, even if you get your day in court. Okay? The better remedy is to not give DCF veto power, have a single judge who already knows the case, have a evidentiary hearing or a trial protecting confidences of the two sides, and make a decision. And whoever doesn't like it is on a level playing field, and they can appeal it, okay?
The other thing this does is it allows the person who was chosen to join in, which I don't necessarily have as much a problem with, because again, to me, that's overall of like leveling the playing field for everybody. I mean, it's a little weird to say I filed a lawsuit and now this person gets to come into my lawsuit, but I mean, within the law there are people who are indispensable parties
or
anyway.
interveners.
So it's not right. So it's not something that's unheard of. So that part doesn't bother me so much, because I think lay the facts out for the judge and let the judge hear it and decide. So this bill I think is very problematic. So I love the other one. I mean, love it. There's things I would change about it, but I like the other one, and I absolutely hate this one.
The other one needs a slight bit of moderation.
Yeah, I think
this bill needs to go away.
So we probably, we could wrap up, and we could always do like a longer kind of thing, or maybe if you guys have questions, like you're welcome to call us, because we enjoy discussing legislative changes. But what can some of our clients and people out there do then? What do you think if they don't like this bill?
Last year, a number of the local foster parent associations led a grassroots campaign to reach out to state senators and representatives, explaining their perspective on this bill and why it should not pass.
Yeah. So maybe we can kind of spearhead some letters that people can send, or give samples of letters. That's kind
yes,
of
and that was circulated too, because people don't have time, or they're not familiar to conversing with state representatives.
People are busy,
they're busy
raising
children.
foster children.
Right.
But that's what happens, and then these things get passed that affect everybody, affect children, and nobody.
And
it's
you
like
don't know
quietly.
what hit you.
Yeah,
Right.
you don't even know he hit you.
Right.
So last time it kind of worked out, I think.
Last day, it died on the last day of the session.
Last year with this exact kind of.
Yeah.
Was it the exact language?
No,
I think it's a little different,
it's
but
a
it's
little
the
different.
overall
It's a little
sentiment,
different. Yeah.
right? So we have a question C. Foster parents need a law, rule, regulation that if a foster child is reunited and then returns to foster care, the original foster parent should have first right of refusal in taking the child. So, yeah, there's no law that says that, right?
No, and if you remain on good terms with your workers, even though you're frustrated with the outcome that led to the return to the parents, they may accommodate you and be sympathetic to maintaining that relationship of the child with the original foster family.
Is there anything in the administrative code that says they have to do that?
I have never seen anything
I haven't
that says
either.
that.
That's interesting, though. So that's kind of a matter. So a lot of times, I mean, I think all of the foster parents know, and I feel like I knew this very intimately as a foster parent, is like, people have to like you, which is hard for me. But
I don't think so.
Yeah, it is. But like, that's part of it. Like, part of it is maintaining those good relationships and making sure that the workers like you, the guardian program likes you, the parents like you. It's like towing that line all the time, because you want to be a fierce advocate, but you also can't disrupt what they're doing and act that you know totally better than they do, and all those different things. But so it is a hard line to walk, I guess. But the statute does currently say that anyone can ask for a change of placement. Now, I've seen courts interpret that differently, because I've had a court in Broward say, well, I can ask for the change of placement by filing the motion, but I can't argue it. So I don't know what that does for me. But actually, we got the placement changed in that case, because there were other things we can do. So if you end up hearing about that happening, I think certainly contacting an attorney and getting a consult isn't a bad idea, because there might be ways to make that happen, whether through litigation or without. Maybe it's just some phone calls, because I think most people do want stability for children within the foster care community, and including the caseworkers, depending, or I like to think that. So, all right. Well, so that's those two bills. There is another bill I wanted to just point out, which is House Bill 875. And we're not going to go through that one because if you can see, that one is a very long bill. This, in my opinion, expands the Guardian program and what they're allowed to do. And so I'm sure people have different opinions on that. And so maybe we can do another video where we share our thoughts on that. But it's interesting to know, in my opinion, that a lot of times the bills, there was a bill last session trying to help children to be able to be entitled to attorneys. And the Guardian program was the biggest opponent of that bill. So when you read House Bill 875, I think if you keep that in mind as to what their position might be, that kind of, without saying
Everything we say about the Guardian program differentiates the line people in the local communities,
Yes.
some of whom are often the most wonderful people, the most child-centered people, not interested in other issues that might be more common in Tallahassee, from the state office, which has slowly, over the last several years, increasingly accumulated power.
Yeah, I mean, it's a political machine, body, essentially, at this
Right.
point, which has negatives and positives, right? So, but the local people know, my experience has always been that on the local level, everybody's really child focused, so,
Yes.
and does want stability for children. But I think when you're reading House Bill 875, maybe keeping some of that in mind. But maybe we can do another live on that. So if you guys have any questions, if you want to know how you can get more involved, because I always hear from foster parents or really people that have already adopted and they're kind of done with the fostering, they say, I want to get involved in change, in legislative change. This is how it's done. So this is the behind the scenes. So contact us to find out how you can get involved. We're happy to direct you, and we don't gain anything from that other than we want to see our clients prosper and the laws to be good for them and for children. And then, but if you also have something going on with your particular case that you think the new laws will affect, or, if you've heard us talk about some of the old laws or current laws, you're welcome to reach out to us. So we'll record this and we'll post it, and we thank you guys for tuning in. Take care.